On the 8th of July, 2026, 5 state attorneys general and the Federal Trade Commission put out a settlement with John Deere, and the language in it is everything we asked for. For 10 years, Deere has to hand farmers and independent shops the same repair resources it hands its own authorized dealers, software included. I read that press release standing in my shop in Iowa with a coffee going cold, and I will tell you plainly that I felt something close to relief. Then I did the arithmetic on the money that came with it. Deere is paying those 5 states $1 million total to cover what it cost them to sue. And on the separate class action, the checks going out to farmers work out to about 79 cents an acre for 8 years of it. That is the part nobody put in a headline, what the settlement actually says. The states are Illinois, Arizona, Michigan, Minnesota, and Wisconsin. The order runs 10 years, and it names 4 specific things Deere can no longer keep behind the dealer door: reading, clearing, and resetting electronic fault codes, reprogramming electronic components, restarting a machine after an emissions shutdown, which is the one that has stranded more of us in a field than any other, and viewing and searching the technical manuals and troubleshooting guides. Those are real. Those are the exact functions I used to charge for. Let me say one thing, and then I will not bring it up again. What I learned behind that dealer counter about billing is in a manual called the Equipment Freedom Manual. It is at getacreon.com, linked in the description and the pinned comment. If you want it, it is there. That is all. How we got here. This is the 3rd time Deere has promised us this, and you need the first 2 in your head to judge the 3rd. Back in 2018, an industry group representing Deere and the other equipment makers signed a statement of principles with the California Farm Bureau. It promised farmers and independent repair facilities electronic access to the manufacturer's tools, software, and documentation on fair and reasonable terms. Investigators at the Public Interest Research Group and reporters at Vice went looking 3 years later and found the deadline in that document had come and gone, with the specifics never delivered. Then came the 8th of January 2023 at the American Farm Bureau Convention in San Juan, Puerto Rico. Deere and the American Farm Bureau Federation signed a memorandum of understanding, and the ag press ran it as a breakthrough. Read the trade the Farm Bureau made. Deere would provide access to tools and information. In exchange, the American Farm Bureau agreed to encourage its state organizations to refrain from introducing, promoting, or supporting right-to-repair legislation at the state or the federal level. Our own farm organization agreed to stop pushing for a law in return for a promise from the company the law was aimed at. And the fine print let Deere charge a fee or a subscription for the access, and carved out anything touching power levels, safety features, or emissions controls. When the 2 sides disagreed, the document sent them into a good faith discussion rather than into a courtroom, which is another way of saying the farmer had no remedy at all. That was the deal made in our name in Puerto Rico, at a convention hotel, by an organization that takes our dues. I want to be careful here, because the men who signed that memorandum are farmers too, and I am not going to sit in Iowa and call them crooks. They took a promise from a company that had every reason to keep it and every ability not to. What they gave up in exchange was the only thing Deere was actually afraid of, which was a statute. 2 years later, on the 15th of January 2025, the Federal Trade Commission sued Deere anyway, with Illinois and Minnesota alongside it, which tells you exactly how much the Puerto Rico promise was worth. The money. Here is where a win turns into something else. Alongside the government settlement, there is a private class action in federal court in northern Illinois. Deere agreed in April of 2026 to put $99 million in a fund, and a judge gave it preliminary approval on the 18th of May. The class is more than 200,000 farmers who paid a Deere dealer for major repairs going back to the 10th of January 2018. Now watch the 99 million move. Court filings indicate class counsel is likely to seek around $51 million in fees and costs out of that fund, more than half. What is left is roughly $79 million split among more than 200,000 operators, which comes out near $395 a man. A farmer in Butler, Missouri named Jared Wilson filed a formal objection asking the court to reject it, and his filing calls the amount a slap on the wrist. Set that against what the restrictions cost United States agriculture. Public Interest Research Group priced it in April of 2023 at $4.2 billion every year, $3 billion in downtime, and $1.2 billion in excess repair charges. 8 years of that against $99 million, and Deere admits no wrongdoing in any of it. Subscribe if you believe a settlement should cost a company more than the thing it was doing. What it looks like on the dealer lot. A court order is a document. A parts counter is a building. The order says Deere must provide these resources on fair and reasonable terms, and every operator who has bought a subscription to anything knows how much room lives inside the phrase fair and reasonable. It says nothing about how fast a login gets issued or what training a man needs before the software will talk to his machine, or what happens in year 11 when the 10 years run out and the monitoring ends. A 10-year order on a company that has been building tractors in Waterloo since before my grandfather bought his first one is not a life sentence. It is a weather delay. Willie Cade, who has spent years on this fight, put the compensation at 79 cents an acre for 8 years of Deere abuse, and that phrase belongs to him rather than to me. The Federal Trade Commission was here before, 4 years early, in a different industry. In June of 2022, it moved against Harley-Davidson and against the maker of Westinghouse outdoor equipment for warranty terms telling owners that independent repair or aftermarket parts would void the coverage, which violates the Magnuson-Moss Warranty Act. Deere's legal department watched that happen in 2022. The Puerto Rico memorandum was signed 7 months later. The lawsuit came 2 years after that, and the settlement 2 years after that again. Every year that clock ran was a year of billable diagnostic hours nobody is getting back. The honest part. My own headline says Deere lost in court, and that is not what happened, so let me correct my own title before somebody in the comments does it for me. Deere did not lose. Deere settled twice, and in both agreements, the company denies the allegations and admits no wrongdoing. There is no verdict anywhere in this. And the other side has a real point that I am not going to talk around. This settlement is genuinely better than the memorandums that came before it, and the people who have fought this for a decade say so. Nathan Proctor at Public Interest Research Group, who has no reason to go soft on Deere, said the company has now agreed to make available all the materials needed to conduct repairs. The difference is enforcement. The Puerto Rico document had none. This one has federal and state supervision, compliance reporting, and protection against Deere retaliating on a farmer who fixes his own machine. That is not nothing. That is the first version of this promise with a consequence attached. So both things are true, and I would rather hand you both than pick the one that plays better. We got the access, on paper, for 10 years, and it took a federal antitrust suit to get it after 2 voluntary agreements failed. And we got about $395 each for 8 years of paying a dealer to plug in a laptop. A farmer near Charles City who waited 11 days for a technician in 2021 is not made whole by that check and never will be. But he was right. That is the thing to hold on to. Every man who said the lock was about revenue and not about safety has a federal settlement in his file now saying he read it correctly the whole time. Subscribe if you stand with the operators who were right about this 10 years before the government agreed with them.